Good afternoon, everyone. To the Honorable Vice Chancellor, Professor Murlikannam sir, Professor Vasanthi ma'am, who taught us Constitution here about a decade ago. It's been a decade, I can't imagine. Every time I come to campus, I feel nostalgia. I don't know how many of you have been forced to come here on a Sunday or how many of you are here for an attendance for clinic, but I've lived through that experience and I don't know if I should pity you or be happy that you're here. Now, a few pointers because we're already running late. I am the problem of the system. I work as a judge. I'm a judicial magistrate. So there is, all the criticism that you would have done yesterday. Yeah. And everything that Justice Muralidhar was also saying was correct. So I'm not here to defend my folk. Okay, there is a problem. But however, I must say that while there is, of course, there's a blanket of denial when it comes to dignity, for the accused, etc. We often overplay the infrastructural issues in the courts. There is good infrastructure in the courts. It is a very easy thing to blame that there is a lack of infrastructure when we don't get things done. But that is not really the case. At least I can speak for my state or a few states where the infrastructure is pretty decent. As far as judges are concerned, the lifestyle, I guess, again, is pretty good. It's not as bad as often it is portrayed, saying there's too much work or hectic. It is. But you need to understand a few basics with how we work as well before I actually come to this topic. You see, what we are given are targets. So in every state, the High Court has made certain rules as to the targets we are supposed to achieve. I speak for Andhra Pradesh and Telangana because even after bifurcation, none of those rules have changed. Both the High Courts, both Amravati and Hyderabad, have simply adopted the same rules as it is. So there's a thing called units that we have to achieve. Now, in this state, we are supposed to attain 17 units as a judicial magistrate, 17. How do you, per month? Now, how do you get those 17 units? Is each matter is given a specific unit. So, for example, let's say there's a civil dispute for perpetual injunction. Someone has tried to occupy your land, but you've instituted a civil suit saying that interference should be refrained from. Dealing with that civil dispute, you get 1 unit if you dispose it after full trial. Okay, we call it AFT, after full trial. You get 1 unit. For a CC, which is calendar case, let's say criminal cases, you get 1 unit if it is done after full trial. If there's a compromise, there are no units. If it is disposed of in Lok Adalat, there's a 0.25. Now, whether that happens through compulsion or with that person's consent doesn't matter, but it's 0.25 units. What makes it worse is that there are additional units for matters which are older than 5 years and 10 years. Now, I'm saying it's worse is because, see, on the outset, the intention is good. We want older matters to be disposed of very easily. But that creates a psyche, a thought process amongst judges that if there's a matter of 2020 pending before me right now, I have 3,000, 4,000 matters pending before me, ranging from, let's say, maintenance cases, domestic violence cases, civil disputes, money suits, all of that. Obviously, criminal cases as well. Now, if there's a matter of 2020 before me right now, if I dispose it of this year, I'm going to get 1 unit. But if I simply wait till the end of this year and dispose it off in January, I'm going to get 1.5. So you see, to reach our targets, I honestly think that, the human in us dies a slow death once we join the process, because now we are obviously thinking of the units that we have to achieve. It's not just sufficient to get those 17 units. Then there is grading. If I get 50% more than that 17, my ACR will say good. if I get double of that 1734, my ACR will say very good. And very recently, the High Court has said if I get triple of that, my ACR will say excellent. And all of this will be taken into consideration for my promotions. Or if at all there is any problem, in any allegation, then this will defend me saying, I've been disposing so many number of matters, so allegations are very natural. Some person who is not happy with the judgment might have made those allegations. So this is the atmosphere that we work in. That's one. Second, when we were talking about remands, because Justice Muralidhar had specifically, spoken about remands, it is absolutely true that the judges do not really converse with the person who is being sent to judicial custody. Now, there are a few problems there. I'm not defending judges here, but also the way the FIRs are written and the power, the discretion that the police have in framing the charges goes a very long way. I'll give you an example. Very recently, let's say last week or 10 days ago, there was a remand that came before me where the allegation was of Section 326 of IPC, which is causing grievous death by using dangerous means or weapon. So grievous death, grievous hurt, I hope all of you know the definition of grievous hurt. If grievous hurt is caused by using a weapon, a dangerous weapon, then that is covered by Section 326. Non-bailable offense, triable by magistrate. So remand comes before the magistrate, yes. But the remand file also has sections from the SC/ST Prevention of Atrocities Act. The victim, of course, is a person who comes from the SC community, no doubt. But the first question the inspector had come with the remand, and the first question that ought to have come, in a judge's mind is, was there an offense based on caste identity? Or at least, did the accused know that the victim belonged to certain caste? If no, then he was obviously oblivious to the fact that he had this caste identity. So 326, maybe you can make that offense, but will the provisions of SC/ST Act attract to that? That's debatable. So when I asked the inspector saying, you've said SC/ST Act here also, but there is nowhere in the remand report saying that the accused had assaulted or hurt the victim because he belonged to certain caste or they even knew of them. He openly said, no, sir, I don't think they knew that he even belonged to a caste. Okay, then why did you put the SC/ST Act there? Because the victim belongs to that thing. But what's the reason? And the inspectors, generally the police, thankfully they're quite frank also, that they simply go on to say that we have to create a history sheet on this person. So the more number of FIRs that are registered against a person, there is a history sheet. Now, when we say habitual offender, and this is what the remand reports also say, that the person has to be taken on remand and sent to judicial custody. The SHO, the station house officer, writes this in the remand report that the accused should be taken on remand and sent to judicial custody because he's an habitual offender. Offender implies that he has committed an offense before. He simply is named in several FIRs, but he's not an habitual offender because not a single case has yet been proven against him and he's not been convicted yet. But even when a person who has 3 FIRs, 4 FIRs against him, they're still in crime stage, being investigated, that the case did not even come to the court, charge sheets are not filed. Even in such cases, you have remand reports very commonly referring to such persons as habitual offenders. And there are judges, and it's a very routine matter, where judges remand such accused on this ground, saying that it has come to our notice that so-and-so FIRs have been lodged against this particular accused earlier. Hence, it appears that prima facie, on the face of it, this accused is a habitual offender. So letting him out right now, there can be multiplicity of crimes that can be committed because it is his propensity to commit such crimes. Hence, what we are going to do is we're going to send him to, judicial custody. He has done nothing yet. It's just allegation. And in this particular case, they wanted to create that history sheet. So the question was this, that, okay, fine, let's remand him right now. But there are no allegations on the under the SC/ST Act, only under the IPC 326 will send him to jail. Where does he have to go for a bail? Where can he file a bail petition now? Can he file before a magistrate? No. Because if it was only 326, he would have filed before the magistrate. But since there are charges under the SC/ST Act as well, he will necessarily now have to appear before the special court, Sessions Court, which is designated as special court for offences under SC/ST POA Act. Even though the inspector or the SHO investigating officer agrees that SC/ST Act was wrongfully included there. Similar things will happen. Similar things normally happen with PDPP Act, which is Prevention of Destruction of Public Property Act. Same thing, mischief done on the road. It's very easy for an investigating officer to add a charge under Section 3 or 4 of the PDPP Act. Suddenly, it becomes bailable only by the special designate court, which is Sessions Court. And then the process then goes on to be really cumbersome. So that's one thing. Second, when we talk about dignity now here, when a person comes from, let's say, a marginalized community or an economically weak background, it's just the police who have arrested him, sometimes the investigating officer, who comes to the magistrate along with the accused. There is no advocate, there is no counsel present there at the time of remand. But when you have a person with means or with sufficient human capital that he can actually have a bigger voice, you will see that a lawyer or an advocate will also accompany the accused at the time of remand itself. And at the time of remand itself, the counsel or the advocate will argue against judicial custody and say that this person has to go. So that one thing, the law does not mandate for a counsel to be there at the place of remand, which ideally I think it should. Because at least at the place of remand, you have a counsel representing the case of the accused, which does not happen now. That's one. Second, then there is a problem of remand extensions, and this has been increasing quite a lot these days, especially in the last 1-2 years. It has come up, it has multiplied. Remand extension says the magistrate can only send a person to judicial custody for 15 days at the maximum, because that is what BNSS 187 or CRPC 167 says. The habit of producing these accused persons for remand extensions, that is dying down. So you will see either, video conferencing, it is allowed. So from the jail authorities can do video conferencing and the accused can be produced through video conference. But there is a practice which is in vogue, not just in this state, but across the country, where the accused is not at all produced. There is absolutely no information from the jail authorities. And despite that, the judges go on to say, accused is not produced, remand extended for the next 15 days. And there are cases which have about 6 months, 9 months, and even a year of remand extensions with absolutely the accused not being produced. There is no whereabout of the accused. If the judge directs someone from his office to contact the jail authorities will simply give 2 reasons. Reason number 1, we do not have enough staff, escort to send this person to this particular court. Reason number 2, he has several cases pending, against him. So he has been produced in another court because there we needed him for remand extension. And that keeps going on. So much so that the jail authorities have simply lost the warrants that were issued by the court, saying, we don't think there was a warrant issued against this person from your court. So imagine when there is no warrant, and if this person now goes to, let's say, High Court for crossing of the bail, and the High Court does insist for the case file to come to the bench, and then they want to go through it, tracing out this file itself will take weeks of time. So that's an issue. You see, when we talk about dignity, it's very obvious that there are these practices which are in vogue. Then there is, of course, as Justice Muralidhar also pointed out, that the issue of if you might have visited the trial courts, but it is very common. I've seen this. It has happened quite a lot in my court also, where the accused are even asked to leave their footwear outside the court and enter. Whereas even the attenders or advocates, everybody, obviously they have their shoes, chappal, everything, but the accused are supposed to leave their footwear and then enter the court hall and stand, with their hands folded and then keep, when you ask the accused to sit, there are 10 people objecting saying, no, sir, this person is accused. He's not a victim or a witness. How can he sit? And that itself, even for the accused, you see, it's so internalized that when you ask the accused to say, he hesitates at least thrice, saying, is it me or is the judge telling someone, behind me, or how am I allowed to sit? Because it's so out of fashion for him to even sit in the court hall that when you ask him to sit, he'll go like, okay, I'll sit, but then he sits without comfort, and then he's sitting on the bench, but he's half sitting, half standing. And the moment, any time during the evidence, the accused is referred, he stands up, and then he says, okay, my name is taken, so I have to stand up. So that sort of this thing. So much so that the advocates have also thought in many cases that when a judge asks an accused to sit, there is an apprehension that the judge might be siding with the accused because, okay, well, this doesn't normally happen with other people, then why is it this judge being too kind to that accused? So now the judges have to be like, no, if I ask the accused to sit, the advocates will think I'm, talking to the accused outside the court, so I'm not allowed to do that. Now that fear comes again. So you see how this is reinforced. It's so normalized that only when you come to places like this that you talk about these issues. But the biggest gap, happens where, before I was actually posted, I went through 1 year of training. Not a single time that we actually spoke about, let's say, the aspect of dignity in our judicial academy. Not a single time, not a single lecture, not a single minute we spoke about dignity. We talk about remands. We talk about giving benefit of doubt to the police. You know how benefit of doubt is given to the police? Let's say, for example, there are several violations in remand. Accused comes. And the first thing, let's say, I would ask the accused is, what's your name? Because I want to tally that person's name with the identity, saying if this is the same person or not. Okay. First question then, when were you arrested? He'll say, okay, today in the morning. Are you sure you were arrested today in the morning? Yes. It's necessary because he cannot be kept with the police for more than 24 hours. So we need to identify that. Now, let's say the accused says, I was arrested 3 days ago. 3 days ago, you were arrested. I was asked to come to the police station. I was made to sit. I was put in the lockup for one entire night also. Next day I was let go. But today I was again arrested. So what was that 1 day for? Because he was let go for, let's say, 1 hour. Then there's a break. So the police is not counting that as a part of custody. All right, you were arrested, let's say 3 days ago. Were you beaten? He hesitates because obviously there are police around. So you have to send all the police outside and then you ask him, were you beaten? Then he hesitates again because he thinks that obviously telling the judge would mean that the information will pass on to the police and then it might happen. Third time when you ask him, he might admit saying, yes, I was beaten. Okay, maybe to admit or maybe to elicit information about who are the other co-accused accomplices in the crimes, for whatever reason. Or if there's a theft or robbery, then recovery of property. It's a very this thing that he was beaten to trace out the property. These are obviously gross violations. The practice is this, and this is what we are taught at the Judicial Academy, that despite all of this, if there are good enough reasons to remand, you still send him to judicial custody. And you simply make a note that the accused has reported ill treatment in the hands of police in the remand order. Hence, explanation is called for from the investigating officer for these violations. And the investigation officer is given 1 week time. This person is sent to jail. The letter goes to the investigating officer. The IO then replies to that letter. And now the IO says that, all of what, obviously he's not going to admit, he's going to say everything that the accused has stated is a lie and that did not happen. We arrested him on the same day. He has, enmity with the police, so he's making accusations against us and all of those things. And I have yet to come across a case in about 4 to 5 years of, me working in judiciary where any action was taken against the police. The judges simply say explanation perused, noted, no further action. They sign it and they leave it. Worse, it doesn't even go into the same file. So if, let's say, there's a conviction and if an appeal happens or whatever reason, let's say there's a bail petition that is filed in the High Court, the High Court does not come to know that this has happened. An explanation was called for and this was the explanation. Because that communication with the police is treated separately. So where you see lapses in that process, those lapses are covered up so well, but the normalcy then continues. And this happens, and the Judicial Academy is not supporting or not conducting any session, obviously has this thing of like the judges are not sensitized enough to even know that there are these issues that they need to this thing. And obviously there is that, internalized, you call it casteism, communism, or even patriarchy, that obviously comes in, and the judges don't realize that they're behaving from those perspectives. Even if you prod them and think that you did this, there are 100 excuses where they find that it was on merits, but it was not due to such prejudice. Then there is issue of legal aid, because this is one big thing, and Professor Mullikan also has been working on this. The problem again with legal aid is this, that lawyers who are appointed as legal aid counsel are not really interested in this matter. I'm not mincing the words at all. They have no stake in it. They are appointed by DLSA, District Legal Services Authority, has a panel of lawyers who work as LAC, legal aid counsel, but there's absolutely no stake that they have. They're not getting any fee. So for them, they simply have to file something for the sake of doing it. There was this thing about 2 months ago where I got a bail petition which said that the accused is a Nigerian citizen and he's a student, he's studying in Bangalore, and he has come here for his education, and because of his race, he was arrested, etc., etc. The accused was here, and I asked him what was his name, and he said, "Sir, my name is Ramesh." I said, "Are you a Nigerian citizen?" "No, sir, मैं तो झारखंड से आया हूँ, यहाँ पर काम करता हूँ." Why does the bail petition say Nigerian citizen? Because 1 week ago, there was a bail petition which was actually filed by a Nigerian citizen there. And this legal aid counsel simply went to the clerk and said, "Can you please give me a bail petition with this person's name?" He did not change the contents of the bail petition. It was copy pasted. The names and the number, crime number, and the names were changed. The petition was filed as it is. And this is what the legal aid counsels do. So even if the bail is given, the problem then comes of sureties. It's a huge problem of how sureties are. Number one, sureties, especially of those people who have means to produce surety, is a big thing. You either need a person who has a government job to act as surety because he'll come with his salary slip and say, "You can attach my salary." You need a person with some land or house to say that this is house valuation certificate and this is this thing. Or if the judge is kind enough, then fixed deposit as surety, but again, money has to be paid in the bank immediately. Fixed deposit receipt has to be taken, saying 10,000 rupees ka fixed deposit has been done, and that fixed deposit receipt has to be filed. Will the surety pay the money for fixed deposit receipt? He won't. Again, obviously, the burden is on the accused that he has to get all of this arranged. Then the bigger problem is of insisting for local sureties. If a person coming from UP, Bihar, or Jharkhand comes and commits a crime in Telangana, and you insist that he has to furnish local sureties, he's not going to get a single one. His own employer will not come as surety. If he's coming in working as a labor here in construction business, his own employer will say, "I don't know this person." And this person is in jail only because, not because he didn't get bail. He got bail, but only because he's unable to furnish local sureties. And that's a big problem. Even though the Supreme Court highlighted it many times. I mean, Justice Krishna Iyer, in this case, Motiram versus State of Madhya Pradesh, 1978, he said, when you insist for local sureties, the judges are betraying the idea of unity in India, because you're saying that a person from, let's say, Tamil Nadu cannot stand as surety for someone from Bihar, because then you're saying that, these people are different, and the entire unity of India itself at stake. Several instructions, but despite that, the prosecutor, the police will come and say, "We need, local sureties, because if local sureties aren't taken, then we will not be able to trace this person again during trial, and the case will be pending. He'll go back home to Bihar, and we will not be able to do it." So there are these issues. Then I'll simply conclude, because I think I'm taking too much of time. Then we come to trial, and at that time of trial, number one problem, of course, is witnesses turning hostile, and how do you handle that? As I mean, the advocates do it pretty well of how doing this. I'm not arguing against the advocates, but sometimes it so happens that I often say the pendency in the cases, I think you can ascribe the liability of up to 90% to the advocates at trial courts for why there's such a large pendency in the trial courts. Because even if an advocate, I have seen this anecdotal evidence, of course, personal, but I've seen many advocates simply say, even if they're winning the case, they would still want to be winning the case next year rather than this year, because they would want to keep the case file with them, for as far as possible, because that's a recurring income for them. But there is that problem of advocates prolonging for sure. They lead to these hostile witnesses, and the witnesses come simply and say that we don't know anything about this case. And even if there's a conviction, a bigger problem is that when, let's say, there is good evidence that a person has actually committed the offense, at the time of sentencing, the problem that a lot of judges face is that the process itself has been such a huge punishment for the accused that sentencing just appears to be an additional punishment that you're giving, which is not how it's supposed to be. That the fact that he has come to the court every month, once every month, or maybe twice, for about 5 years or 6 years, that itself is such a big punishment that even if that person is let go, I think he has served his punishment for whatever he might or might not have committed. So that's one thing. And whenever you're taking liberty out of, liberty of an accused, the intention of the police is very clear, that it is sort of to teach a lesson to such persons, saying if we don't send this person to jail, then others may be emboldened and commit more crimes, and it sends a bad message to the society, or he himself might take law to be a very light matter, and he might commit further things. So the reason as to why an arrest is happening, and the reason that are put on paper as to why the arrest happens and why the person is sent to judicial custody, they are completely different. You will see that the reasons recorded in a remand order will say it is essential for this person to be kept in judicial custody because he may abscond, because he may tamper with the evidence, because he may threaten witnesses, or because he may commit further crimes. So I'll conclude, just 1 minute. So there are reasons that are written, but the actual reasons that the police have are none of these. The actual reasons, of course, is to make sure that that power structure is maintained, and and to ensure that lesson is taught immediately at that juncture, not at the conclusion of the trial. There are many other issues that I wanted to flag out during the trial as well, but I guess there are other speakers, so I'll conclude here. Maybe if there are questions, I'll take it. So thank you so much.